everyone, my name is Poonam Harjani and I am the leader of Taxman's Advisory and Research Support Services. Taxman's Advisory and Research Support team comprises of distinguished experts on income tax and GST matters who support businesses in being fully tax compliant, optimizing their tax positions and mitigating litigation risks. In today's video, I am going to talk about a contentious issue for the automobile industry. The issue relates to claim of input tax credit on demo cars under the GST regime. As a routine tax practice, the car dealers purchase cars for demo purposes from the original equipment manufacturers. At the time of such purchase, of course, GST is being paid by the car dealers. The question is whether the car dealers can claim credit of such GST. Before analyzing the issue further, let's first look at the provisions under the Central GST Act that restrict credit on motor vehicles. Section 17(5) of the Central GST Act of 2017 restricts the credit on motor vehicles for transportation of persons having approved seating capacity of not more than 13 persons, including the driver. This restriction is, however, subject to three exceptions, namely when the motor vehicles are used for taxable supplies of A, further supply of such motor vehicles, B, transportation of persons, and or C, imparting training on driving such motor vehicles. So there are two parts to the provision. One, which are the motor vehicles which are restricted and the restricted motor vehicles are motor vehicles which are with approved seating capacity of not more than 13 persons, including the driver. For the sake of simplicity, I will call such motor vehicles as specified motor vehicles. And when these motor vehicles are used for making the supplies which are listed under clauses capital A, B, and C, the credit is still not restricted. When it comes to the claim of input tax credit on demo cars, the authority for advanced rulings and the appellate authorities for advanced rulings have been passing contradictory orders. In three of the orders, the authorities for advanced rulings of three different states have come to the conclusion that the credit is eligible. However, on the other hand, in four orders, the authorities for advanced rulings, including the appellate authority for advanced rulings in the state of Haryana, have concluded that the credit is not eligible. In coming to the conclusion, while passing the orders in favor, the authorities for advanced rulings have considered the following aspects. One, the demo card is a capital good for the car dealers. Two, the demo cards are later on sold at the written down value, and there is no restriction on time limit prescribed under the law so as to be excluded from section 17(5)(a) capital A. And three, that the demo car is an indispensable tool for sales promotion. On the other hand, to conclude that the credit is not eligible, in all the orders, a consistent view has been taken that at the time of purchase of the car, the dealer did not have an intention for further supply of such motor vehicle, and therefore the credit is restricted. Coming to our analysis, in our view, the restriction under section 17(5) clause A is fairly expansive. As long as the specified motor vehicles are not used for the three specified purposes, the credit is barred. No matter whether the credit is the motor vehicle qualifies as a capital good or input, or whether or not the motor vehicle is being used for the furtherance of business of the taxpayer. Therefore, the arguments that have been essentially taken in favor of concluding that the credit is eligible, in our view, are not sufficient to defend the credit eligibility. Having said that, we need to also understand, firstly, the rationale for the restriction on motor vehicles existing under the GST law. The purpose of such restriction is essential, in our view, to avoid the claim of input tax credits on cars which are used for personal purposes. Evidently, demo cars are not exposed to that risk. And therefore, the credit restriction being extended to demo cars is not in sync with the purpose for which the restriction has been cast on motor vehicles under the GST laws. So applying the purposive interpretation, the credit, in our view, ought not be barred. Strictly interpreting the provisions of Section 17(5) Clause A also, in our view, there are two legal arguments which have not been elaborately covered and examined in any of the advanced ruling orders. Firstly, the exclusion under Clause A of Section 17(5)(a), the term such motor vehicles, I'm referring to this part, has been read under the orders where the credit has not been allowed, to mean that the very motor vehicle which is purchased ought to be sold. In our view, there is no such basis for applying such a restrictive interpretation for interpreting the exception clause capital A. If we note that the exception clause capital C also uses the term such motor vehicles, and evidently both these terms are being used in an expansive way, in a liberal way, and that argument has not been fully examined under the orders. Secondly, in our view, it is also arguable that the demo cars are not motor vehicles for transportation of persons. Let's look back at the very first part of the exclusion restriction clause. It reads as motor vehicles for transportation of persons. Demo cars are used for the purposes of demonstration to the users and for test drive purposes. They are not used for transportation of persons. Therefore, in our view, it is arguable that the restriction under clause 17(5) small a is not applicable. And above all, the very fact that the advanced ruling authorities have been coming into two contrary conclusions also highlights the fact that the restriction clause is open to interpretation. And it is a right of law that where there is a particular provision of law is capable of two different interpretations, the interpretation that applies in favor of the taxpayers should be followed. It cannot be denied that the input tax credit loss is adding to the agony of the auto industries, which is already facing immense challenge through these COVID times. Also, there is no explicable reasons on first principles for restricting the credits on demo cars. Therefore, it is humbly urged to the government authorities that they come up with a clarification, or they come up with a clarificatory amendment in the law itself to the effect that the demo cars are entitled for input tax credits in the hands of the car dealers. That's all for today. Thank you very much for being with me on this video. Do not forget to log on to www.taxmann.com/advisory to know more about our advisory services. Thank you very much again and have a good day.